Good morning. This is the 3JX docket. For those of you who have not argued here before in the 3JX docket, the yellow light goes on at 4 minutes and the red light goes on at 5 minutes, so you should conclude when the red light goes on. You have 5 minutes. We will try and refrain from asking questions during those 5 minutes. Proceed.
This is case number 2005-0727 in the matter of John M. Maynard and Ingrid I. Maynard.
May it please the court, I'm Joshua Gordon. I represent John Maynard, who just wants to get divorced. Ingrid showed up late to the party, but she wants all the procedural and substantive benefits enjoyed by the diligent. In our system, you either show up and contest, or you don't show up and forfeit. And I think Ingrid just can't accept that she forfeited. This court cannot address the default. It was twice litigated in May 2003 and July 2003. The transcripts of those hearings are not before this court. Based on those transcripts, based on those hearings, the court found whatever it found in its orders. And it was twice litigated, twice decided. Default is in the court's discretion. The court found that Ingrid got notice and that she took no action, that she defaulted. The issue was not litigated at trial. It was mentioned at trial, and there was some explanation at trial, but it was not litigated, and the court made that very clear. There's no transcript here to dispute the factual findings that are in my client's favor. Any assertions that are mentioned in the brief are in pleadings. They're not under oath. They're not by affidavit. They're not subject to cross-examination. All that stuff was in two hearings that the record of which just are not here. Even after Ingrid appeared in July 2002, a year lapsed before she asked to strike the default. There are consequences of default, and one of them is that you can't ask for affirmative relief. That you get a Douglas hearing only on the split of property. There's constitutional issues in that, of course, and Rule 185 says that you have to answer in order to claim alimony. After you default, there's limited access to the court process, limited ability to present evidence. You can cross-examine and object, but no affirmative relief, no discovery, no affirmative requests of the court. That is the consequences of default, which can't be assailed here. As to alimony, there was no answer. The proposed order that my sister cites was a settlement document. It was a proposed order early in the litigation. It doesn't put alimony in play. Ingrid also has lots of assets. As a result of this order, she gets 60% of most of the stocks and bonds, a chunk of the retirement, 60% of the sale of the houses, health insurance. Not in the record is that her parents are wealthy and she'll take a bunch of that money. My client has paid all the expenses for her, all her living expenses, with the exception of the 10 months that she was in the state hospital. He has paid all her expenses since 2002 in February when he filed for divorce. 2 houses, 2 mortgages, 2 sets of utilities, 2 taxes. He's paying for her car. He's paying for his son's high school and college education and her health insurance. And all this is in lieu of alimony, and that also is in one of the proposed orders, in lieu of alimony. In fact, that's in the temporary orders, that in lieu of alimony, he would do all these things. These things have been going on now for 4 years. That is a better deal than the proposed alimony that he put in his proposed order, a better deal for Ingrid. If there's no questions, I'm all done.
How do you see the effect of the alimony statute vis-a-vis the rule concerning the answer?
Well, Norberg says that you can't contract out of the alimony statute, and I think you probably can't contract out of any statute. But there are consequences of default. Default means no affirmative relief, and affirmative relief is requesting alimony.
Sure, but alimony is akin to child support in that one can seek a modification up or down at various periods of time. an alimony order itself is subject to modification, assuming it was properly entered in the first place, up or down, or stop, or what have you. So I'm sort of wondering about the interplay between the statute and the rule.
My answer to that is that if Ms. Hickey's position were the law, then there would be no consequences of default. You wouldn't, there'd be no, people might strategically default if that were to their advantage, because there'd be there's no detriment to defaulting. You can show up whenever you want and have all the benefits of a divorce trial. Then what would be the purpose of filing an answer? And I think it starts putting procedure on its head.
Thank you.
Still have the grounds for divorce that would be uncontested and conceded by the default, wouldn't you? You have the fact of divorce and the grounds.
Well, I think a default takes as all the well-pleaded facts,
Right.
that if fault is pleaded in the initial petition, it's taken. If it's irreconcilable differences, it's taken as well. I don't, maybe or maybe not, you can contest. My position would be you can't contest the liability, the divorce itself.
When can she file for alimony now?
I think she's precluded from filing alimony.
Forever?
I think forever. The statute says that if alimony, I think the statute says that if alimony is granted, then you can request it periodically. But if you don't show up, you forfeit.
On the Douglas case, and the case talks about valuation and distribution at the final hearing. The Douglas case did not talk about alimony, did it?
No.
Does that mean, therefore, that, following along with Justice Duggan's question, why wouldn't that be open? In other words, you can't contest well-pled fact. You can't contest the grounds for the divorce as sought. That's the liability finding.
Right.
But why isn't the balance of it open for a contested hearing?
Well, if we were going to put it in terms of liability and damages, I think alimony and all those things, maybe there's an exception for child support because there is a child and a different interest involved. But for alimony, it seems plainly within the damages in the liability and damage sort of paradigm. And that's what you forfeit. In Douglas...
No, but if that's true, I mean, typically in these pro confessor cases, liability is resolved against you.
Right.
But the consequences of the liability is open, as it was
Damages.
in Douglas. So if valuation and distribution are alive for property, why isn't alimony alive as well? That's not a liability.
Oh, I think there's an enormous difference between property and alimony. You already own, Ms. Douglas in the Douglas case already owned what it was that the court needed to split. So you get a hearing on which piece of your estate you get to keep. There's constitutional rights in that property. There's no constitutional right in alimony.
So the Douglas case was concluding that when it comes to alimony, the game's over if you've defaulted, and they only played the game on valuation and distribution of real property or personal property?
Because you already own it, and the government can't just take it away.
The petition here was filed in February, and she was defaulted in April? Is that correct? 2 months?
Yes.
It seems awfully quick. Now, I never did a lot of divorce work, but it seems awfully fast to have a default 2 months after the petition is filed, and I don't think there are any intervening hearings, were there?
No, I think that was the first hearing, but I don't think it was odd in terms of civil procedure generally, so I don't think so, where you get your orders of notice and you have to file an answer or an appearance and all those papers by the return date specified, and that was litigated in these 2 hearings, and apparently that happened or didn't happen.
Right. Thank you, Mr. Gordon.